In this session, we're going to talk about agency law. Next, let's talk about fiduciary duty. A fiduciary duty is an obligation to act in the best interest of another person or entity. So the fiduciary duty example, classic one is a trustee. A trustee of a trust has an obligation to the trust benefits to act in a fiduciary duty. Um, in that example, the trustee can't do anything that would harm the value of the trust for the beneficiaries. So he can't take the money and invest it in something that's going to lose money or is very risky. That would be against his obligation to act in the best interest of the beneficiaries. Same thing, you have a corporation, they have a board of directors. The board of directors has a fiduciary duty to act in the best interest of the shareholders. They've got to make decisions that protect and should be in the best interest of the shareholders. So there are a number of components to this fiduciary duty. The book talked about a few of them, and there are a few more that we'll talk about over the next couple of slides. It, a lot of these duties derive under Delaware law. Delaware is a very unique uh, state for all this corporate law. There is something, and I don't remember the exact number, but it's something like 50 or 60% of all major corporations are incorporated under the laws of Delaware. Excuse me. By being incorporated under Delaware law, Delaware is very adept at the business rules, the business law components of corporations, LLCs, things of that nature. And so, for that reason, I looked at the duties, the fiduciary duties as defined under Delaware law. And we'll talk about a few of these in a moment. So, the first is a duty of loyalty. Under the duty of loyalty, which is a component of the fiduciary duty, the concept is that the agent has a duty to act for the benefit of the principal. The agent can't act on behalf of themselves or for private interest of someone else, like a sibling, a father-in-law, a spouse, a great best friend, whoever. They're prohibited from acting in the interest of someone else or themselves. And instead, under the doctrine of a duty of loyalty, they have a duty to act in the benefit of the principal. Let's take an easy example of an employee who works for a corporation. Um, as an agent of that corporation, he has a duty of loyalty to the corporation. So if he decides that he's going to open his own company, he would be violating his fiduciary duty, specifically the duty of loyalty, if that employee started trying to solicit the employer's clients away while he's still working for the employer. So if you have an employee who is uh, going to open his own business and he calls on clients in a sales position, if every time he starts calling on clients near the end of his employment there and starts saying, hey, by the way, I know I'm filling this order, but I'm also going to be opening my own company and we're going to be selling the same product. Um, Here's my new card and contact information. I'd love it if you give me an opportunity to try to, beat this price and get your business. Obviously, in that scenario, that employee, as an agent of the company, is acting for his own benefit, not the benefit of the employer. He would be in violation of the duty of loyalty. So, the next duty that is a component of this fiduciary duty is a duty of care. So, an agent has a duty to try to avoid mistakes and errors. The agent is to try to act in a manner in which he's prudent and he is careful in making decisions. Part of that means that the agent has a duty to become well informed before he makes a decision. So you're acting with a duty of carefulness when you have gone out and you've read the material, you've asked for help, you've gotten all the information that you can to help you make a well informed decision. Next, you have a duty of obedience. These are some of the ones that I'm saying came from Delaware law. Duty of obedience, the agent has a duty to abide by the principal's reasonable and lawful orders. So if the corporation tells you that you must uh, sell a piece of property, even if you disagree with it, as the agent, you have a duty to abide by the order of the corporation to sell the piece of property. Duty of confidentiality, the agent has a duty to keep information confidential if it's required. That kind of speaks for itself. Duty of disclosure, an agent has a duty to act with complete candor and thus must disclose all facts and circumstances that would be relevant to a decision. So if the um, employee, the agent, knows information and doesn't disclose it, he could be in violation of his fiduciary duty because he's supposed to act in the best interest of the um, employer. And in that scenario, if he's not acting with complete truthfulness and candor, he may be violating his fiduciary duty. Last is there's a duty of good faith. So the agent has a duty to perform his or her duties in such a manner that is reasonable and does not violate the law. So let's talk about the agent's authority now. An agent has the authority to bind, is the legal term that's used, the principal through either actual or apparent authority. By saying they have the authority to bind the principal, we're meaning they have the authority to commit the principal to doing something. The easy example is they have the authority to bind the principal to a contract. So if they execute a contract saying that we'll buy, widgets or we'll buy property, they have the binding means that they've committed the employer to buying that material or buying the property. So actual or apparent authority is the terms that are critical here. So an agent has to act with either actual or apparent authority. If they lack that authority, then the activity is considered outside the course of their scope and should not be binding. Maybe scope's not the right word. Outside their authority, and therefore would be an act that's not binding on the principal. So what is actual authority? Actual authority is where the principal intentionally and purposefully tells you, agent, you have the authority to act on my behalf to do X, Y, and Z. An example is in a board meeting. The corporation gives the CEO the authority to execute contracts to purchase another company. They say, CEO, we authorize you to memorialize and facilitate and execute the purchase of a corporation. So actual authority is usually documented in some form or fashion. Most often in the setting of a entity, it would be in either the board minutes or in some operating agreement or bylaw. Usually the authority is memorialized somewhere. And it's important that that authority is memorialized in some record and that authority or that record is kept so that if there's ever a question about the scope of somebody's authority, you have that record that helps show it. So you'll hear them referred to as actual authority can either be expressed or it may be implied. So express actual authority, that's exactly what you would think it is. It's where the principal gives unequivocal authority by either words or action. An example of words is the CEO directly tells the HR manager to complete the employment contract for the new operations supervisor. In that instance, it's clear, it's unequivocal that the HR manager has been given the authority to act as an agent on behalf of the company to execute an employment contract. So by action, an example would be where the CEO just sends the HR manager the signed offer sheet. If you send the signed offer sheet to the manager, and the manager is obviously expected to then complete that hiring, and that would include um, putting together an employment contract and having it executed. So by there, you're telling them you've got authority to complete this hiring. So express authority can also be found when the agent has a, quote, justifiable belief, close quote, that the principal gave the authority. So in the example above, on the action, if the CEO sends the HR manager the signed offer sheet, the HR manager has a justifiable belief that the CEO wanted the HR manager to hire that new operations supervisor. Through that, the HR manager would be reasonable in his reliance upon having actual authority to hire the person. So if there was a question about it, there would be a justifiable belief and it would be binding on the corporation. Implied actual authority. This is what you would expect it to mean. It's where um, the agent may also have implied authority to act as is reasonably necessary to complete a task. So you can derive this by either looking at usual authority, in other words, the authority that would typically be given based on past instances. So every year something happens, and every year you've been given the authority to complete some, the example here is the CEO instructs the VP, operations VP, to plan the company retreat. The operations VP has implied authority to execute the contracts to rent meeting space and hire a catering company. Um, that could be implied based on that's what we've usually done in the past, and that in the past he's always been told you need to, rent the meeting space and hire a catering company, and you've got authority to do it. So if they've had that authority in the past, then that would be applicable here. You could also have implied authority based on custom. So that's the authority that the agent would usually have. If you looked at outside the industry, it'd be customary for the employee to have that authority. So in this example of the VP planning the company retreat, it's implied that he has the actual authority to execute contracts to rent meeting space and hire a catering company, because in order to plan the retreat, that's part of what he would have to do. You'd have to have a place to meet, and you'd have to have food to eat. Apparent authority um, exists when the third party is led to reasonably believe that the agent has the authority to act for, on behalf of, the principal and has the authority to bind the principal. So this is where you haven't expressly been given authority, but the third party is led to believe that the agent has actual authority. So it can exist based on the words or acts of the principal, or based on past history. So if the agent has in the past had authority to act, then it's reasonable to believe that the agent continues to have authority to act on behalf of the principal. Um, the principal can make comments or take steps to lead a third party to believe that the agent is the one who has authority to act on their behalf. It's important to note that it's the principal and not the agent that creates apparent authority. So if the agent is the one who's saying, I've got authority to do X, Y, and Z, that can't create apparent authority. It's got to be words or conduct by the principal that establishes apparent authority. So the example we have here is the CEO tells a third-party vendor that the VP makes all purchasing decisions. Well, that's words by the principal, the CEO acting for the principal, that the VP has apparent authority, that they have authority on making purchasing decisions. So the third-party vendor reasonably believes that the vice president has authority to execute a purchase agreement, when in fact he may not. But in this scenario, because of what the CEO has told the third-party vendor, the vendor is led to reasonably believe that the agent has authority to act on behalf of the principal and execute the contract. If you have where the agent performs an unauthorized act, if if the agent really, in the last example we just did on apparent authority, if the agent really didn't have the authority, that is that BP, to execute the purchase contract with a third-party vendor, that can be cured through ratification. So the principal has the authority to ratify the act, and it cures the lack of any authority. Once that purchase agreement is ratified by the company, then the act is as if the agent had the authority all the time to bind them. So it cures the lack of authority. Undisclosed principal, this is another concept that comes up in these dealings. It is lawful for the principal to remain confidential, private, unknown. So if an agent is acting on behalf of a principal to a third party, and the third party may know that they're acting as an agent, and they may want to know the identity of the principal, they have no legal right to know who the principal is. Under the law, the principal can remain unnamed, unidentified. So there are times when it's strategic for the principal to remain unknown. So if it's a valuable company or a highly wealthy person, then it's strategic for them to perhaps remain anonymous, because if the third party knew who the principal was, they may try to seek a premium out of that person and seek a higher amount of money to buy a piece of land or to perform some service. So it makes sense that there are times when an undisclosed principal has its benefits. In this scenario, if the agent acts outside of their authority, the principal should not be bound by that act. So if the agent exceeds any scope of their authority that's been given to them, whether it's express or implied actual authority, if they operate outside of that authority, the principal, their undisclosed person, would not be bound. However, the third party may have a claim against the agent. So the agent could be held personally liable in that undisclosed principal scenario. Respondeat superior, this is just a little more on that doctrine. We talked about it when we talked about the differences between the employment relationship and the independent contractor relationship. So the employer of an agent will be liable for personal injuries or property damages that's caused by the agent while the agent's acting in the course and scope of their employment. Like I said earlier, this doctrine is also referred to as vicarious liability, and this doctrine is limited to employees, not independent contractors. So the key to liability is that the agent employee must be acting in the course and scope of employment. That makes sense. You go back to the example we used of the employee who's driving a car on the weekend versus an employee who's driving his car during working hours and driving it for a purpose of the employer. So if it's a person that is a salesman, if he has an accident while he's driving from the office to an appointment to meet with a client about purchasing some product, that accident would be one that would be within the course and scope of his accident. And if the employee was negligent in causing the motor vehicle accident, the employer may be liable to the third party that suffered harm in the accident. But if the employee was driving on the weekend and he was driving from his home to his son's baseball game, he's obviously not working at the time of the accident, and his employer would have no liability in that example. So here you've got some factors that's applied a lot of times to help, because sometimes there can be a gray area as to whether the employee is acting in the course and scope of their employment. So let's go back to the example of the employer, employee's employee. He is a salesman. He's leaving his office, driving to an appointment with a client, but he decides that he's going to quickly swing by the bank and get some money out so that he can take his wife out for dinner later that night. Is that really something he's doing for work, or is that really something now that he's doing on his own personal time? And assume that as he's traveling to the bank, he has an accident. Well, who's liable then? Is the employee acting in the course and scope of his employment, even since he's technically en route to a client, or is he outside the course and scope of his employment and now he's pursuing a personal endeavor? So some of these factors that you would look at is whether the employee's act is authorized by the employer. In that instance, he's authorized to travel from work to the client's office, but the employer really hasn't authorized the employee to drive from work to the bank to then the client. Next, you consider what's the extent of the employer's interest. Are they being advanced by this act? Going to the bank to get money out to take his wife to dinner, while a good and noble thing, is not advancing the interest of his employer. Next, you look at whether the employer furnished the instrumentality that caused the injury. It's a possibility that in this example that the employee is driving a employer-provided car. So that one would, if there was an employer-provided car, that would support that it had an element of being in the course and scope of his employment. However, that's not alone dispositive. And then lastly, you look at whether the employer had a reason to believe that the employee or know that the employee would be performing this act. In this instance, the employee may have told the employer that I'm going to go by the bank and then I'm going to go to the client meeting. They may not have, it's not specified. So that reason could go either way. And so in this scenario, it's kind of a gray area of, is that little detour to go to the bank enough to remove him from the course and scope of his employment? In my opinion, in that scenario, I believe it's most likely that a court would find that the employee was still within the scope of his employment because he was only taking a momentary short detour for personal reason, but the overall reason for his trip was to go on a visit to the client. So that conclusion brings us to the detour versus frolic concept. So the detour is considered a minor deviation from the employer's business, and it would still most likely be considered within the scope of employment. The deviation to the bank is a short, small, out-of-the-way deviation. Now, if he deviated and went to the movies and watched a movie for 2 hours, and then after leaving the movies, coming back to go to the client visit, had an accident, that's much more of a frolic, which is a substantial deviation from the employer's business and is outside the scope of employment. So in the example that we just gave, I think it's more akin to a detour than a frolic. So it's still possible in some scenarios that if the employee is considered to be acting outside the scope of his employment or her employment, that the employer could still be liable. Here are some of the reasons. So the employer intended the employee's conduct or consequences. The employee's position makes him or her the company's alter ego. The employee's actions attributable to the employer's own negligence or recklessness. The conduct violated a non-delegable duty of the employer, meaning that it wasn't something that the employer could trust to the employee. Or the employee purported to act on behalf of the employer and there was reliance on apparent authority. These are all a very facts and circumstances based determination to know when you could impose liability on the employer even when the employee is acting outside of the scope of their employment.